आज से एक दशक पहले रियल एस्टेट इंडस्ट्री अनेक अनियमितता के साथ अनऑर्गेनाइज सेक्टर के नाम से जाना जाता था, लेकिन जब से रेरा यानी कि रियल एस्टेट रेगुलेटरी अथॉरिटी के आने से इस इंडस्ट्री में बहुत हद तक अनुशासन के साथ साथ ऑर्गेनाइज सेक्टर के नाम से प्रचलित होने लगा। इसमें देश भर के अनेक हाउसिंग एक्सपर्ट का योगदान रहा। इसमें हाउसिंग गुरु के नाम से प्रसिद्ध मुंबई के रमेश प्रभु का महत्वपूर्ण रोल था। बता दें कि सन 2013 में केंद्र सरकार रेरा लाने की सोच रही थी। तब फाइट फॉर रेरा फोरम के साथ मिलकर होम बायर्स के लिए आवाज बुलंद की। 2014 में आई नई सरकार ने रेरा कानून संशोधन बिल के लिए पार्लियामेंट सिलेक्ट कमेटी में रमेश प्रभु को शामिल किया और रमेश प्रभु द्वारा दिए गए सजेशन को रेरा बिल में शामिल किया गया। और आज एक दशक के बाद भी रमेश प्रभु रेरा के बारे में ग्राहकों और प्रोफेशनल्स के लिए जन जागृति और एजुकेशन कर एम्पावर कर रहे हैं। हाल ही में उन्होंने ऑनलाइन के जरिए रेरा पर महत्वपूर्ण प्रस्तुति दी। दिखाते हैं रमेश प्रभु ने क्या कुछ कहा इस ऑनलाइन मीटिंग में।
We welcome you, Prabhu sir. Over to you, sir. Thank you so much.
Let me thank for giving me an opportunity to dwell into various aspects, that too starting from the basics of RERA, background, importance, structure, and of course the role and responsibility of a professional. We as a chartered accountant have a major role to play in this sector. So with this, let me start the presentation, and all the participants, I welcome you. Certainly you will have a great learning, basics, background, importance, implementation, structure, and the stakeholders and role of professionalism. And the journey of RERA has started much before the RERA could come in from Maharashtra. I take pride that Maharashtra, we had a Maharashtra Ownership Flat Act in the year 1963, and other states have just adopted that act to protect the interest of the flat purchasers or the allottees, that is now called as. In the year 2012, Maharashtra Housing and Regulation Development Act was introduced in Maharashtra, and thereafter with the provisions of Maharashtra Housing and Regulation and Development Act, which were enacted in 2012 for the first time in Maharashtra, the same thing, most of the provisions are taken in Real Estate Regulation and Development Act 2016 by the central government. And I am very fortunate to be a part of the Parliament Committee when this particular thing was before the Select Committee of the Parliament, and I got an opportunity to deliberate, discuss, guide, and also I am fortunate to interact with the law officer in Ministry of Housing, where I could interact, give some suggestions, and which was very well received, and that is how we can find the final act. February 2015, yes, the law was enacted, rather it was with a major amendment, it was presented through the Select Committee. And also I want to just put one more aspect, that I am also part of the fight for RERA, which had taken this movement across India and then interact with the government, other stakeholders to see that the RERA gets implemented. Within 1 year, that is 15th March 2016, Lok Sabha for the first time passed the law, and on 26th of March 2016, it got published in Government of India Gazette, and it was supposed to be starting from 1st May 2017. Now, within 1 year, there were so many things to be required to be done, and that you will see that yes, RERA approved it in the year 2016 March, 10th March 2016. 25th March we received assent of the President, and 20th April 2017, within a period of 1 year, we got Maharashtra government publishing the rules. So this way, this is a small journey. Now the question comes, when it got notified, the act got notified effective from 1st May 2016, but in the first 6 months, the central and state government was required to make the rules, and then another 6 months they were supposed to create the appellate authority, real estate regulatory authority, appellate tribunal. This way, there was a period of 1 year, and thereafter from 1st May 2017, this RERA was supposed to be getting implemented. I again take one more pride saying that Maharashtra is the first state along with MP. These are the two states who implemented online RERA registration from 1st May 2017 itself. So they did not take much time. The question comes, who is RERA? RERA is a regulator in the real estate sector. Now to register the real estate projects, first register the real estate agent, monitor development which is happening, supervise the construction that is happening, redress the disputes, control the entire system and also the sector wherever there is some pitfalls, and ultimately the only aim is to protect the stakeholders. When I talk about stakeholder, it is not that only consumers are being protected, it also protects what is known as all the stakeholders. Who are the stakeholders? Naturally, the first stakeholder is none other than the consumer, whom we call it as a allottee. Second stakeholder comes the mediator between the promoter, that is a real estate promoter, developer, builder, contractor, whatever we name call, and the consumer, that is a real estate agent. And the last, of course, stakeholder is the promoter themselves, the developer, contractor who constructs, sells, landowners. So these are the stakeholders. In addition to these stakeholders, there also has provided the professionals as a stakeholder: architect, engineer, chartered accountant, then your advocate. See, these are the stakeholders, structural engineers. So the question comes then, how the law is effective? Whether the law is prospective or retrospective or retroactive, what is the law? Naturally, law is not retrospective. It is not that May 2017 the law has come effective. Now what will happen to the projects whose project has been completed prior to 1 May 2017? Naturally, that is not applicable. Now the question arises, there is a project which has started in the year 2015, 2012, 2010, maybe 2017, before May 2017, but the project is not completed. There is no completion certificate issued. Will they covered under the RERA? The answer is yes. So therefore, the RERA is applicable on all ongoing projects, new projects which is starting from 1st May 2017 and the project which is started prior to 1st May 2017, but where the completion certificate is not issued or where the projects are not completed, they are covered, which is called as an ongoing project. And the new project, whether it is a commercial, residential, plotting, everything is covered under RERA. Now the next question arises, there was a MahaSeWA Ownership Flat Act. There are so many laws which is regulated, which is whether it is a development control promotion regulations, whether it is a income tax, whether transfer of property act, Maharashtra land revenue code, various things are there. If there are so many things already in place, why this act is required? Naturally, in spite of so many laws, this sector is highly unregulated. Secondly, there is no transparency. Whenever the transaction has to happen, what is important is there has to be transparency. No information. The informations are not shared. No easy redressal of the dispute. Delay in possession of the property. The projects are taken ongoing or under construction. So what has been promised is not delivered. No occupation certificate. No building completion certificate. Some unscrupulous developers do demand cash. They don't form the housing society. They don't convey the land and building. No agreement. No amenities which are agreed are shared. No maintenance of accounts. Sections 5 of MOFA, Maharashtra Ownership Flat Act, provides that accounts has to be separately maintained. It is not done. They sell open parking. They sell stilt parking. In spite of the Honorable Supreme Court judgment in Laluchand case versus Panchali Coping Society of Mumbai, where it has been held by the Honorable Supreme Court that parking cannot be sold under MOFA because they are the common amenities, but still they are selling. Fraud and cheating by unscrupulous developers. I am not saying every developer is there, but yes, the number of people who do unscrupulous transactions or the fraud have started increasing. Without approved plan, the building used to be getting constructed. They are all illegal buildings, but they used to get constructed, sold, and no title deeds, nothing, no plans. Very important, the problem is flats are sold at super built up area, which is called imaginary area. We can understand the what is known as carpet area, where the carpet can be levied and it is measurable. Built up area also one can understand because this is how the plans are being passed, where the building built up can be understood. But a super built up is the area which is not measurable at all. It is in the air. Some developers say my super built up is 30%, 20%, 50%. So in case of shops, they would say 100% super built up. Means you are paying for carpet area of 100 square foot and buying 100 square foot, you are getting possession of 100 square foot, but you are required to pay for 200 square foot, which is a great mistake. But then the question arises that yes, what is the pitfall in the existing system. That is the background in which we are working today. What is the background? Background, all these issues are there. Why these issues were prevailing in spite of there being a Maharashtra Ownership Flat Act in Maharashtra, Karnataka Ownership Flat Act in Karnataka, Goa Ownership Flat Act in Goa, Gujarat Flat Owners Act in Gujarat, all were done to protect the interest of the consumers and to say what are the duties of the builder, how the projects has to be disclosed, what are the society to be formed, how apartment deed has to be made. All this is mentioned there. The challenging point in the Ownership Flat Act is that there is no enforcing mechanism. In a traffic rule, if there is a traffic rules are made, everything is there, but if you do not have the constable or the traffic hawaldar that we call it as, and traffic police, naturally there is a tendency to break the law because nobody catches. Today we know CC camera technology has gone to such a level, every signal there is a CC camera which acts as a technically a police where the fines are being put. So therefore they are taking necessary precaution. So if there is an enforcement mechanism that can work well, but in Maharashtra Ownership Flat Act there was no regulator, there is no authority who would prevent, monitor and resolve the disputes. So this type of all the mechanism in any sector, in anything, what is more important is there has to be any system has got three important things. What are the three important things? There has to be preventive measures in any regulatory provision or in the law. There has to be monitoring, supervision, controlling, and the last one is if there is any dispute that should be resolved. In unless putting a wish list in the MOFA, there was no monitoring, neither there was a supervision, nor there was any dispute redressal mechanism. So therefore, it was a half-hearted attempt and which was made at that prevailing time, and as the central government realized, union government realized, and Maharashtra government also realized in the year 2009-10 that we need to come out with a comprehensive regulatory system for the real estate in Maharashtra, and of course central government also realized if this is in the concurrent list, special contracts are in the concurrent list, why not we in the central government do it? Accordingly, the central government also took a lead after the enacting Maharashtra Housing Regulation and Development Act 2012, and that is how we can see the RERA has come in. So the most important, as I said, in the absence of enforcement, the compliance is missing. If the compliance is missing and I want something, naturally I need to get into the other law. Which are the other law? Naturally RTI, or maybe going to the court, engage the lawyer and fight in the court for several years after paying lakhs of rupees, or now it is a crores of rupees to the developer, and who will fight with that unscrupulous developer will fight with our own money. Now the question comes, what is the difference in the RERA? If I have to compare how the RERA is different from the MOFA, Maharashtra Ownership Flat Act, naturally here also the disclosure, as Gautam Chatterjee has rightly pointed out, the major problem is of a disclosure. Now the disclosure, because of the technology, leverage, online registration, it becomes open document. So that is one disclosure which is already there in MOFA. Now in the RERA, it has been said that it has to be online. So across 28 states and number of union territories, totally about 60 union territory and state together about 35 to 36 RERA authorities are there, and each of the RERA authorities, union territory as well as the state, they are now available online. So this way the implementation has started taking place. To the extent I would say Honorable Supreme Court was kind enough to pass a direction, give a direction that about 3-4 years back, that all the state and union territories should establish a regulatory authority within a period of 3 months, and that is how a judiciary involvement also is there, that they have also realized that the working of Real Estate Regulation and Development Act is most important. Another thing I can always say that Bengal, Mamata Banerjee government decided that they will not implement the RERA, but certainly they will go into their own West Bengal Housing Regulatory Authority, HERA, Housing Regulatory Act, which West Bengal has started. But when the matter was referred to Honorable Supreme Court said nothing doing. Once the central government has done a law in a concurrent list, other states have to follow. This way, now the RERA, the implementation is done across the country and the union territory. Now the question comes, in RERA, what is the much different? The RERA absolutely have one question called Real Estate Regulatory Authority, which ensures compliance and enforcement. Not only they do the compliance, they also do the enforcement. Now, as I was saying, that in any regulatory system, three-fold measures are very important. What are the three major fold? One is prevention, second is monitoring, and the third is dispute redressal. And therefore, all these three you will find in the RERA, which I will discuss little later. So the compliance is the one which is helpful for monitoring. The next comes the RERA with the three people, authority appointed by the state government. They also can make some mistakes. So therefore, the appellate tribunal, first appellate tribunal has been set up in every state and union territories to hear the appeals of the real estate regulatory authorities, if you are agreeing. So this way, regulatory authority and the appellate tribunal. There is one more authority called adjudicating officer, because the adjudicating officer decides about the compensation payable. Now you will see what is this competent authority all about. The competent authority is nothing but a planning authority, what we call as the authority set up by the state government in order to approve the plan, sanction the building and sanction the layout. So the competent authority will pass the plan, which is already was there earlier also. Now they will do, and once they do, it will come back to the regulatory authority, and then the projects will be registered. And then of course we have dispute redressal and other things. So this way, the most important is compliance and service delivery by the promoter as per the agreement for sale, and the rules and the regulation which is made is improved upon. And now you do not require to go to RTI or other things. Common members can still file a complaint before RERA authority or appellate tribunal and get the orders against the promoters, developers. Does it mean that promoters cannot go? Yes, if the consumers also or the allottees do not comply with some of the requirement, don't make the payment timely, or they don't cooperate in the implementation of the some of the requirement, naturally the action also can be taken against the allottees also. Now coming to the, that is how the RERA has been established. Now the question arises, what are the objectives of the RERA? Naturally, the objectives of RERA is threefold, which of course, as we already said, the threefold objective is regulation and development. Real estate, when we talk about regulation, controlling does not mean that the moment regulatory system comes, regulation brings a lot of promotion, development. We have seen IRDA, whether it is an insurance regulatory authority, we have seen SEBI for capital market, we have seen RBI for a finance market, we have seen various regulatory authorities which has come, whether it is an electric authority. So many authorities have come, and wherever there is an authority, even insurance company, we have seen insurance regulatory authority, wherever the regulatories have come, the business have grown, the system has grown, and the accountability has grown, and that is what we look at. And the development is possible only when there is the authority. So therefore regulation. So regulation and development is the first objective. Second objective comes transparency, efficiency. What do you mean by transparency? Transparency is something which is required to be conveyed to the stakeholders or the end consumer and to be made in the public domain. So that transparency will help bring efficiency. In transparency related to the completion of the project, milestone, and from the where the money comes, whether the money has been properly utilized, not utilized, accounted for, and it is put in the public domain, that is where the transparency comes in. The moment transparency comes, naturally the efficiency follow, because because there are so many eyes which will be looking into the transparent system. The ultimate aim of this real estate sector is to protect the consumer interest, allottees interest. If there are allottees, because of them the project is getting started, and if their interest is not protected, naturally the entire project becomes failure and unscrupulous developers can take the consumers for a ride. Now how it is being done? It is done with a regulatory system. As I already said, there is a regulatory authority and then the appellate tribunal. Now the question arises, what is this Real Estate Regulation and Development Act 2016? I coin it as a mother of real estate development law. Why I call it as a mother of real estate development law? Because this law is applicable across India, which you can say except Jammu and Kashmir. This is wrong. Originally it was except Jammu and Kashmir. Now after August 2019, 5th August 2019, when Jammu and Kashmir has been made a part of 370 article has been removed, since then it has become a completely Article 370 is not applicable, no more applicable to the Jammu and Kashmir. Therefore, the RERA also has become applicable across India, including Jammu and Kashmir. And let me tell you, even Jammu and Kashmir regulatory authority has been already set up. So, therefore, it is a mother of real estate law for across India. The next comes, it relates to not only owning and acquiring rights, it also has owning and acquiring freehold right as well as leasehold right. So that means it is, if you look at Maharashtra Ownership Flat Act, it only talks about ownership. It does not talk about leasehold rights. So here is the case where the leasehold rights are also covered. A matter came of Lavasa Corporation in the Mumbai, where Maharashtra, I would say. In Pune, there is one place called Lavasa, where the developer used to construct the building, give it on lease basis, long lease basis, 99 years, 999 years, and then take the money, and they were saying that RERA is not applicable to them because it is not ownership, we have given on lease. But the RERA did say that the RERA is not, authority did say that it is not applicable to lease because it is talking about ownership. But when it went to the appellate tribunal and then when it traveled to Honorable High Court, both appellate tribunal and High Court said the long lease is also covered under RERA because ultimately you are taking the money in the form of premium as a construction cost and the land cost, and you have not completed the project in time, and therefore even before the project could be completed, if you are given on rental basis, it is understandable that RERA is not covered. But otherwise, even on a leased property, RERA is covered. The third important thing why I am saying mother of real estate law is because it has got apartments, which means the apartment, I'll deal with the definition of apartment little later. All the property which gets under construction is covered as an apartment. Now it also covers plotted development, which was not there in MoFA or Maharashtra Apartment Ownership Act or any other law. So the plotted development was never getting regulated. So apartments only was getting regulated in Ownership Flat Act. Now the plotted development is also covered. Third important, building. If you are constructing a building and selling, those were not covered under MoFA. Now even this is covered. So this way the building is also becoming an important part. Now the question comes, if it is applicable across India, then how gets implemented? Naturally, the implementation is the second point today that I need to discuss. So it is implemented through the state government and central government. Central government through their officers in the union territory and the state government for their respective state. Why the RERA is getting implemented by the state? Because of twofold reason. One, the entire land is a state subject. So Maharashtra is governed by Maharashtra Land Revenue Code. Karnataka is covered by a Karnataka Land Revenue Code. Under the constitution, land is a state subject. So therefore, any development that takes in the land under the respective state development rules also are covered by the state government. So if the land is a state subject, development control regulations are under the state government. Maharashtra, we have Maharashtra Regional Town Planning Act. Karnataka, we have Karnataka Town and Country Planning Act. UP, we have UP Country and Town Planning Act. So every state government has their own country or development plan, or Maharashtra has got a Regional Development Plan Act. So this way, the respective states are managing the development. They are also taking care of the land. So therefore, the legislator thought it fit that let the respective state government look into the implementation of the RERA by setting up their own rules, regulations, regulatory authority, and enabling the provisions that is done by the central government. Now, as I was saying, what do you mean by apartment? The apartment means independent unit. We in Maharashtra call it as a flat. Now, the flat does not mean it is only residential. Apartment does not mean it is only residential. It covers residential unit, shop, commercial, garage, bungalow, and also industrial galas. Industrial estate also is covered, office, row houses, or any area that is going to be constructed and or to be constructed and it is sold, office premises. Anything, everything, whatever the nomenclature you call it as, you call it as a structure, you call it as a chamber, you call it as office, you call whatever the name you want to give. If you are constructing and selling with a covered area, or you are just doing a open plot, you are doing a plotting with the common amenities and you are saying it as a layout approval, that is also covered under RERA. So therefore, any this of the units which are provided or agreed to be provided by the developer promoter to the purchaser or an allottee for a consideration or even otherwise also consideration allotted are covered as the same as independent apartment. Now the question arises, what are the functions of RERA? If you have said all these, then the question comes, what are the functions? Naturally, the first function, what I have done is I have made into 5 important segments under which RERA works. So some of the important sections I have captured here. One is most important is administration. When you talk about administration, administration of not only the office and their employees and all office work. In fact, even the administration of the project also comes under the administrative function, because when you want to administer your office, you want to administer the project, naturally you are required to come out with so many things. So the entire administrative provisions are covered under section 25. The second comes naturally judicial function, because when you talk about administration, administration talks about RERA registration, it talks about RERA monitoring by way of various regulatory provisions, and it also talks about administering and monitoring, taking various reports from the promoter. Everything comes into the administrative functions which is given in section 25. The next comes, yes, judicial. What is that judicial? So the judicial is something which is in case of any dispute between the stakeholder. Who are the stakeholders? Naturally, the main important stakeholders are promoter, that is a developer. The second is estate agent, real estate agent, and the third is allottee. In this particular transaction of real estate, if there is any dispute between these 3 people, they can file a complaint being aggrieved under section 31 before the RERA or before the adjudicating officer. Adjudicating officer is a person not below the rank of district judge appointed by the regulatory authority in consultation with the government. So that is what section 31, aggrieved person can file the complaint. Section 36, naturally it comes as the powers of the RERA, what directions they can give is again given under section 37, and ultimately section 39 talks about rectification. 36 also talks about interim order. If there is some interim order has to be passed by the judicial for taking some immediate step so that further damage is not done, naturally interim order can be passed by the RERA. I'll just give an example so that it makes clear. Suppose a developer has taken, promoter has taken from me more than 30%, and he is supposed to enter into an agreement, register it, and then give me the possession of the premises. But in spite of repeated request, he is not registering the agreement, and he says that unless until you make the payment, I will cancel your allotment, I will sell the apartment to somebody else. Now, having agreed of this situation, he files a complaint with the RERA, and the moment he files the RERA, the one prayer would be that the promoter should be directed to register the agreement. But the RERA may take 6 months, 1 year to hear the complaint. But meantime, if the promoter may sell it to the third party because agreement is not registered, it is not created a charge. So therefore, to fear that, he may go with the interim application saying that the promoter may be restrained from creating a third party right on the flat or the apartment or a plot that I have booked. So this way, the RERA in the first hearing itself can pass the interim order. So therefore, hearing the complaint, giving a show cause notice, and giving all the opportunities is under section 31. The RERA has to dispose of the application within 60 days from the date of receiving it. Then 36 interim order, 37 is the various direction can be given. It can be general direction, it can be even project wise direction, or maybe complaint wise direction, and section 39 is about rectification. All these 4 sections is talking about judicial function. The next comes naturally advisory, because RERA is for the purpose of development. If I need to develop a sector, naturally I need to have an advisory role, advice to the government, advice to the competent authority, advice to the various other stakeholders, and that is why section 32 and 33 gives the power to the RERA, Real Estate Regulatory Authority, to advise the various stakeholders, competent authorities, government, central government, and various other regulators such as income tax and other departments, RBI, all that, and banks. The next comes, if I have got a judicial power, I have passed certain orders, those orders need to be executed. If the orders are not executed, then there is no meaning in what I am passing orders. So therefore, section 40 gives us the executive power, the execution power, even to the RERA, appellate tribunal, and adjudicating officer, which are the main 3 authorities who deal with the complaints. Section 40 talks about this. The next comes regulatory, because RERA, as I said, is evolving. The way there are various systems has to be developed, and there has to be standard operating procedure. There has to be certain circulars, notification, regulations to be made regularly. So therefore, regulatory provisions, the regulations power is given to the regulatory authority themselves. They can go on revising the regulatory provisions, which is given in section 34 and 35. So this way there are 5 functions: administrative, judicial, advisory, execution, executive, and regulatory functions. Now the question arises, whom this RERA is applicable? Who are the stakeholders? Naturally, you and I know that it is the developer who is responsible. No, the developer also includes somebody called the landowner. So therefore, the landowner who causes the construction, who gives the permission to the developer to develop, or contractor to develop, either under revenue sharing or under the area sharing, or a combination of that. Therefore, they are getting benefit from the project. Therefore, landowners are also called as the promoter. The next question arises, the stakeholders like architect, engineer, and CA, they are also stakeholders. I'll just give you an example, so which will make you clear that the architect, as I was just saying, architect, engineer, CA are also equally responsible and accountable. What happened in Maharashtra, one of the architect or an engineer, he gave a certificate to BMC saying that the project is completed, and therefore OC can be issued. Unfortunately, the project was not completed, and the OC was issued by the municipal corporation. The agreed allottees went and made a complaint to the RERA. RERA, in their own wisdom, said nothing doing. Once the competent authority, that is a BMC, has given the completion certificate, OC, we will not get into intricacies. Occupation certificate is already given, so we cannot interfere. But when the matter went into the appellate tribunal and then ultimately to the Honorable High Court, both of them held responsible for that engineer who gave a bogus certificate that the project is not, and thereafter a disciplinary action was initiated against the architect and engineer. So therefore, one has to be very careful. Even though I am a chartered accountant, I am required to do some compliance under the act. I also will get what you call accountable. Similarly, estate agent, advertising agency, customers, allottees are also equally responsible, and the competent authority. Now, what are the silent features of RERA? Naturally, silent feature of the act, if I have to divide into 5 parts. We saw the functions into 5 parts. Now let us look at the silent features into 5 parts. One is, yes, real estate project need to be registered, monitored, controlled, extensions to be given. The project completion is also equally important. So the real estate project registration involves extension of the project, revision of the project, deregistration of the project, closure of the project, and so many extension of the project. The second is real estate agent, of course, for the purpose of registration, giving them the registration number, project registration number for the real estate project. Then filing of the complaint, section 31 is another feature where one can redress the complaint. And then of course when we talk about complaint, naturally in the before appellate tribunal also you can file an appeal, and in the high court you can file the second appeal. So this way filing of complaint and the appeal is also another important aspect. Then the most important in RERA is financial discipline. We have seen that any project fails, real estate project, because of the siphoning of the money or diversification of the money, or when there is no financial discipline. The RERA ensures financial discipline by involving three important professionals. Some of the topic which is given to me is the role of a professional. Naturally, here three professionals or four professionals are majorly involved. The first professional is advocate, who will give the title report, who will prepare the agreement for sale, he will prepare the draft conveyance deed, he will prepare the allotment letter. So the role and responsibility of the advocate comes over there, legal professional. Second is a finance professional, which is a chartered accountant. Before that, architect comes into. Architect, who is a council of architecture, will give a report as to how the projects are being done, what is the percentage of completion, and in order to withdraw the money from the RERA addressing account, architect certificate is required. Third is, naturally we know, engineer. Engineer also estimates the total construction cost or the project cost related to construction. Then as the project is getting completed, he will also estimate how much money has been already invested, and based on that estimate things can happen. The third comes is the chartered accountant. One, the architect talks about percentage of completion based on the approved plan, on quarterly basis or day-to-day basis how much is done. Secondly, engineer talks about estimated cost, and the third is the chartered accountant, who goes through the books of accounts, says that how much money has been invested. This way, if a money has to be withdrawn of the allottees, these three people certificate is required. Therefore, financial discipline ensured that the allottees money which is being received, out of 100 rupees, 100 rupees has to be put in a collection account, out of which 70% will be segregated, which will be used for the project completion only and nothing else. As and when the project money is invested, project it is utilized, then only you are allowed to withdraw from that, and for which three professional certificate is required: architect, engineer and chartered accountant. Similarly, what happens is the 30% money which is remaining, that is available for free flow, which can be further utilized for sales marketing. When we talk about 70%, it has to be used either for the land cost or construction cost, approval, site expenses. It cannot be used for sales, marketing, administration. So this is very clear demarcation has been done. Once the project receives the occupation certificate or a completion certificate, thereafter the project comes out of the RERA, then they can, of course, 100% can be put in a operation account, and then they can utilize. Till such time the OC is issued, the RERA ensures that 70% is put in a RERA designated account, and it is being operated by way receiving a certificate from all this. So unless until these people give a certificate that so much money has been spent and drawing power is given by these three professionals, it cannot be utilized. Now some of the RERAs also have come out with the direction that if the promoter is taking a project loan against the mortgage of sellable units or against the mortgage of the land, because it is related to that project, that money also need to be put in the RERA designated account, so that that money also gets utilized for the purpose of project. So therefore, the units which are unsold, the lender or the financial institution is considered to be the allottee for which they are giving the money. So the way allottees monies are getting regulated, the financial institution money also gets regulated. This way, financial discipline has been ensured in RERA. Transferred consumer oriented, which we already discussed. Now, responsible of the promoter, yes, get the project registered. Declaration has to be given by the promoter saying that when the project will be completed, who are the professionals with whom he will be dealing with, and their names, everything has to be declared, and then he will carry out the audit once in a year, and quarterly he will give the quarterly progress report. All this declaration in Form B, duly notarized on a stamp paper, need to be uploaded. 70% he will deposit in a separate account which will be utilized only for the purpose of land cost and project cost, and it can be for the purpose of project only. No advertisement without registration. The builder cannot advertisement unless until it is registered. Obligation of the promoter, veracity of the advertisement. In case somebody does some mischief in advertisement and missale is done, naturally they are going to be charged. Now the question comes, who is the promoter? In a layman language, it can be called as a builder. Now, registration of real estate project and registration of real estate agent, which has been given in section 3 of registration of a project. Section 3, the operative part, general clause says, all the project, no promoter shall sell, market, advertisement, allot or promote any project or a building or sell any units or a plotted development unless until the project is registered with RERA. So the registration is a primary. However, there is a provision to section 3(1) which says a project which is ongoing where the completion certificate is not obtained as on the date of the effective implementation of the RERA, that is 1 May 2017, then they have to register their project within 3 months from the commencement of the act. As far as new project is concerned, without registration they cannot sell, but which is an ongoing project, yes, they can always sell with within 3 months. But if they don't do it, there is a penalty. Real estate agent given under section 9, unless until the project real estate agent registers, he cannot market. Section 3, there are certain things which are exempted. Very important. Everything is required to be registered. However, there are certain exemptions given in section 3 subsection 2 which talks about if the area does not exceed 500 or it is less than 8 units, they don't require registration. Both the conditions are fulfilled, then only they have to register. Even one of the conditions is fulfilled. Suppose one is exceeding more than 500, naturally less than 8 units, still they don't require registration. That is what MahaSeWA has said, and even the Honorable Appellate Tribunal has said that. However, some of the states do consider that yes, if it is 500, less than 500 but more than 8 units, they insist for registration. So this is being a state subject, everybody takes a call. All the completed where OC is granted is exempted, and the last is redevelopment is not covered, or where the major repairs is to be done by the association apartments, they are not covered. Where there is no reallotment or marketing, that is not covered. Disclosure of information by the promoter has to give a huge disclosure with his what is the he has to pay the prescribed fees, make an online application, number and size of the layout, phases, proposed project facilities, approval for each phase, declaration by the promoter that the title is clear, project will be completed within the scheduled time. He has to give the milestone, and project will be sanctioned by the completed within a period by the competent authority, whatever the timeline gives, and 70% will be put in the RERA dressing account. This form B he has to be given. The registration further comes is grant of registration within 30 days it is given or it is rejected, and if it is not given, it will be deemed to be registered, and then once it is registered or deemed to be registered, a login and password will be given. Promoter will be able to upload the information regularly. If it is rejected, of course one can always appeal, and thereafter when you are rejecting, you have to give the reasons. And the last is section 6, where the project has been registered for a particular period, let us say 5 years, 3 years, within what period he has to complete the project. If that completion period has been set and he is not able to complete, naturally under section 6, by showing a force majeure, he can take a extension of more than 1 year. The next question comes that yes, if there are some illegal things have been done by unscrupulous developer, based on the complaint or based on certain public report, the authorities can cancel the registration. Secondly, after the expiry of the period, the project gets lapsed. Suppose a project is registered within 4 years, he has to complete, he has given that declaration, but 4 years is completed, but he has not completed the project. Naturally under section 6 he may be able to take 1 more year extension. Even after 5 years the project is not completed, naturally the project is considered to be the lapse. In that case, naturally the consequence of revocation or lapse of the project is that it debars the promoter from executing the project, accessing the website. The project then becomes the property of the associate allottee, and then they may decide how they want to get completed. First right of refusal will be with them. The promoter will be declared as a defaulter and display the photographs, and his RERA account will be frozen, and it will be transferred to the associate allottee or a new developer who does the development. Now the question arises, is it possible for the developer to complete even after the expiry of one more year? The answer is yes. Under section 7 subsection 3, he can apply, and with certain terms and condition the project can be further completed with certain conditions, that too by authority given by RERA. Section 9, I just said, an unregistered real estate agent shall not facilitate sale of RERA registered project. Under section 10, it has been said that he cannot, what are the functions? He cannot facilitate sale of unregistered project, maintain a separate books of account, what is prescribed in the income tax about the accounts money which is received, spent, not involve unfair trade practice, facilitate information required by the promoter, rather allottees and documents, any other function as may be prescribed. Now what are the obligations of the promoter? Naturally, section 3 talks about the RERA says that the promoter cannot sell, market any project unless it is registered. Section 4 talks about he has to upload his 5 years track record, project detail in the website. Section 4 subsection 2 and clause L subclause D says 70% of the money has to be put in a separate account. It can be used for the land cost and construction cost, and it can be utilized only after getting a certificate from the architect, engineer, chartered accountant, and on yearly basis by appointing another chartered accountant who is practicing, you can get the audit done, and that audit report will be disclosed on the website. Disclose all the details of the project to the customer under section 11. Form the society as you sell more than 51% of the units, and liable for damages for any misinformation in the advertisement. Section 13 says that the promoter is required to register the agreement for sale if he wants to receive more than 10%. That means the allottees are protected up to 10%. There can be allotment later. The more than 10% can be received only after registering the agreement. Section 14, there are 3 subsections. One, it says that it has to be adhered to the approved plan and specification, and second, it says if they have to change, 2/3 allottees consent is required, explicit consent is required. Third is if there is any defect in the construction workmanship, till 5 years from the date of possession, the promoter is required to make good, and within 30 days of the complaint, if they don't make good, they can refer the matter to the adjudicating officer who will decide the compensation payable, and also may direct the allottee, rather promoter, to carry out. Section 15, it says promoter cannot sell the project once he has marketed, advertised, shown his credential to a third party without taking 2/3 allottees consent, and also without taking the authorities approval. So this way the binding is there on the promoter. He cannot sell the project, because it is possible a promoter may give his brand name, sell, receive, and later on he may hand over the project to the contractor himself and he wants to absolve from his liability. That is not possible. Having marketed the project and registered the project, it becomes responsible on you to change or rather complete it. However, if you are not able to complete, you want to sell, 2/3 allottees should be informed, their consent is required, plus authority also should hear the matter, and only based on that a project can be sold out. Section 16 talks about taking insurance of the title as well as building, because insurance is very important. And section 17 talks about the transfer of the title. Land and building on which project has been completed requires to be conveyed to the association of allottees within 3 months from the date of OC. The last is section 18, refund, compensation, interest on default. In case the promoter is not able to complete the project within the agreed timeline, the allottee gets the right to demand refund of the money paid along with the interest and also compensation. And in case the allottee decides to continue in the project, they can continue in the project. However, they will be entitled to claim compensation and interest for the delayed period. Just to give an example, agreement for sale says he will give the possession by 31st December 2023. But even 2025 has passed out and still I have not received the possession. What I can do is I can complain to the authority telling them That project was supposed to be done by 31st December 2023 as per the agreement. He has received the extension, but I am incurring a EMI loss, I am paying interest, I am losing rent. So therefore, the allottee at the same time wants to continue in the project. He can file a complaint in section 18 and claim for the interest for the delayed position. This way there is a pressure built on the promoter. Now at the end I would say, what is Real Estate Regulatory Authority all about? Real Estate Regulatory Authority is a in between, I have said, it is a screening authority, it is a bridge between the promoter and the purchaser, allottees, collect all the information, approval document, personally involved in the execution of the project, grant the registration, redress the dispute. It is only a screening authority, it is not an approval authority. The promoter gets the approved plan from the Common Authority, Planning Authority, Local Authority like PCM, PMC, MCGM or various authority, and flat purchase is on the other side. It is something like, when the IPO comes, SEBI does the registration, stock exchange gives the NOC, thereafter you are allowed to bring out the IPO so that consumers are not at loss. Same way here is the RERA who takes all the information, verifies, satisfies and then gives the registration. Thereafter only they are allowed to market. This way they become a transparent system. RERA is divided into 10 chapters. Chapter number is preliminary, 2 is registration of agent and project, 3rd is functions and duties of a promoter. Rights and allottees are given under section 19, only one section, 11 sections are subsections are there. Real Estate Regulatory Authority functions are given 20 to 40. Central Advisory Council, which is going to give advice to the central government and the RERA about what need to be done. Real Estate Appellate Tribunal, section 40 through to 53 and then of course 58. Then we have offences penalty adjudication 59 to 73 and then 72, and finance accounts audit reports are of the RERA and miscellaneous 79 to. So the entire RERA is divided into 10 chapters and 92 sections. Rights of the allottees, yes, the allottees are able to get the information and documents, right to obtain the certificate, right to claim compensation, right to withdraw from the project and right to execute the registration of the Satekat, or it is called agreement for sale. These are all sanction plans can be obtained, completion occupation certificate can be obtained, breach of agreement you can go with the authority for claiming compensation, alterations, transfer to the third party is not permitted. So therefore if that is done you can always go for withdrawal. If more than 10% is paid you can demand registration. Before the allottees, before booking, verifying the builder's registration is a must. It's a duty not to buy apartment in an unregistered project, not to pay more than 10% cost without the agreement. Make necessary payment as per the agreement for sale. Interest you can claim, and if you are delayed you will have to pay the interest. Even the way promoter is paying interest for the delayed portion, you are also required to pay interest as per the SBI plus 2% compensation to the builder for delayed payment. Participate in formation of association of allottees, participate in registration for conveyance deed, to take physical possession within a period of 2 months, receiving the occupation certificate. Regulatory system, we have Advisory Council, RERA, Appellate Tribunal, High Court for the second appeal and adjudicating officer. Functions of RERA we have already discussed. It is in the tabular form. It is adjudicating, regulatory, promoters, registration and consumers protection. Functions of appellate tribunal is to hear the dispute of the appeals which is filed and adjudicate the dispute. They are not covered by CPC, and appeal to be done within period of 60 days from the date of RERA order or adjudicating order. Otherwise you can always ask for a condonation of delay. Chartered accountants are allowed to participate and represent before RERA. Cost accountant, company secretary and the advocate are the people who are permitted. We can represent for the promoter or a real estate agent or a consumer or any of the aggrieved person we can represent. The huge penalty is a great thing in RERA, because if you do not comply, naturally you have to pay penalty which ranges from 5% of the cost of the project to 10% of the cost of the project. Even imprisonment is there for a period of 3 years for non-compliance of the various order. Even the allottees are also similar, fines are there. Non-registration of a real estate agent, 10,000 rupees, during which the default continues, and that is where the otherwise 5% of the cost of the flat, apartment or a plot can be taken as a penalty for facilitating RERA sale of a project where it is not registered. Penalty is there for every day of default. So this, if you see all this, so there are various sections where even in the company, the every director, manager who is liable to failure to do the compliance will be penalized. Section 71, 70, 71, 72 is talking about adjudicating officers, compounding of offence, adjudicating officers' power, responsibility, and factors to be considered for adjudication. Miscellaneous, the whatever is decided in the RERA, the bar of civil judiciary is there. Even arbitration, Honorable High Court has said, Bombay High Court has said, even arbitration cannot be done when there is a RERA. Delegation of power under section 81 is possible. RERA can delegate the power. Appropriate government can supersede the RERA if there is something wrong, and they can appoint new RERA. They can issue the direction. The government can issue the direction. Power of the appropriate to make rules. Power of the regulatory authority to make regulations. So this way, since it is implemented from 1st May 2017, Maharashtra Housing and Regulation and Development Act 2012 has been repealed. Now, what are the role and responsibility of promoter, natural or the real estate, what you call professionals? One can understand the project, guide them, and then guide them about the title, allotment letter, advertisement material. One can design the various policies, coordinate with the various professionals involved in the process of registration, upload the information on the website, do the quarterly reporting, completion of the compilation of the data, study the verification of the data, uploading the information, prepare the declaration form B, get the project registered. Project tracking and quarterly reporting is also equally important. Upload the inform, do verification, interact with the professionals like architect, engineer, advocate, guide the RERA compliance, review the project report, comply and verify last year's project undertaken, draft allotment letter, agreement for sale, conveyance deed, booking letter, agreement with the engineer, advertising material. So many things can be done. Standard document will be there. Returnership is another role which the chartered accountant, architect, engineer can play for the various RERA compliance, including quarterly status uploading of the project, consultation of the management of the fund which can be done by chartered accountant, how the project of 70% can be done, review each of the certificate issued, and utilization of whether 100% money has been utilized for the certain things. Preparation of the annual statement, accounts, audit, withdrawal details is another thing. This is my photograph with the Rashtrapati Bhavan. 3 days I was there, where I got an opportunity to decide about MOFA, otherwise Maharashtra Housing and Regulation Act, and when Pratibha Patil was the president. This is some of the books which I had written and I had given, and with my family I had gone there, and I was a guest at Rashtrapati Bhavan. This is a privilege, and yes, Yashwantrao Chauhan, where more than 4,000 participants, housing societies were there. Honorable Prithviraj Chauhan released my book on deemed conveyance, RERA, that time Housing Regulation and Development Act, and entire thing is Gautam Chatterjee was there as a housing secretary, and of course BMC Commissioner Sitaram Kunte, who was earlier housing secretary, then Prithviraj Chauhan and Ashit Dada Pawar, deputy CM, and other cooperative minister. You can see that I was the one. It was in the year 2012. This is Gautam Chatterjee, who was a housing secretary at that time. I had presented him the deemed conveyance book, where I was part of this one. Thank you very much. Whatever information is shared is completely of my information. Don't make organizers responsible, accountable for any default in my presentation. Thank you very much. Let us be a partner in nation building. Let us do something. And thank you very much for giving me this opportunity. And thank you for getting involved in the discussion. Ultimately, the RERA is evolving. Every day we find evolving. And let me tell you, there's so much and so much opportunity. And the real estate is second highest, contributor to the GDP. That second highest generator to the employment. It's the most of a capital intensive, and the regulatory system is going to make a huge difference. And RERA or real estate has touched everybody's heart. And when we talk about basic necessary, food is regulated, and what you call basic amenities like textile, that is food, clothing is regulated. RERA was real estate, housing was not regulated. Now it has got regulated. I think it is going to be a big game changer, and I wish you all the best. Thank you, Vaibhav, for giving me an opportunity. Vinay, I could stress for all the time, and thank you being with me And whenever you wanted, I would have called you. I said, let the flow be continue. So I continue. Thank you very much once again, Vinay, for giving me
Thank
and putting me in this structure. Thank you. Pimpri Chinchwad branch of WRC of ICI, jointly with Credai Pune, BI, Neredco, BDA, who have joined this program and given me an opportunity. I thank each one of you.